are considered part of the law of nature. The scriptures are considered part of the law of nature. That's Blackstone's commentaries on the laws of England. And it goes on, upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human laws should be suffered to contradict these. What's found in the Bible. This is a U.S. versus Morris. Every citizen and freeman is endowed with certain rights and privileges to enjoy which no written law or statute is required. These are fundamental or natural rights recognized among all free people. As a general rule, men have the natural right to do anything which their inclinations may suggest, if it be not evil in itself, and in nowhere impairs the rights of others. So this is all talking about natural law, right? Don't forget to like this video. Don't forget to subscribe to this channel. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. This is my front page. The subscribe button's already been clicked. The bell hasn't, because it would look like it's vibrating if it had. And so the arrow's pointing at the bell, and that's what you got to click. Sovereignty is the right to govern a nation or state. Sovereign is the person or persons in whom that resides. That's Chisholm versus Georgia, 1793. In a common law country, the sovereigns are the people. The law of nature is everywhere. So who are the sovereigns? That's we the people in America. Any common law country. I've seen court cases in Australia, Canada, that talk about the sovereign people. The words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our republican institutions, form the sovereignty, who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of those people and a constituent member of the sovereignty. Canada. This is a Canadian court case. The sovereign people, through their representatives, have created the court and the board as well as the municipal council and define the rights and duties of each. That's Toronto. That's reference Casa Loma. That's a Canadian court case. This is another Canadian court case. The Parliament of Canada and the legislatures of the several provinces are sovereign within their spheres defined by the British North America Act, but none of them has the unlimited capacity of the individual. And so again, same thing in Canada. This is Attorney General of Nova Scotia versus Attorney General of Canada in the Lord Nelson Hotel case, 1951. And this is Australian case, Australia Capital Television versus Commonwealth. Translated into constitutional terms, it denotes that the sovereign power which resides in the people is exercised on their behalf by their representatives. Another Australian case, the powers of government in this country are derived from the people, who are the ultimate sovereign. And England, every individual was sovereign over himself. U.S., this is a New York court case. The people are sovereign and not bound by general words and statutes restrictive of prerogative, right, title, or interest unless expressly named. Acts of limitation do not bind the king or the people. The people have been ceded all the rights of the king, the former sovereign. And that's People versus Herkimer, 1825. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. Chisholm versus Georgia. People of a state are entitled to all the rights which formerly belonged to the king by his prerogative. Lansing versus Smith. It will be admitted on all hands that with the exception of the powers granted to the states and the federal government through the constitutions, the people of the several states are unconditionally sovereign within their respective spheres. U.S. Supreme Court. Ohio Life Insurance Company versus Bolt. This is England. Citizens of London are either freemen or such as reside and keep a family in the city, and such are citizens and freemen, and some are not, who have not so great privileges as the others. The citizens of London may prescribe against the statute because their liberties are reinforced by statute. In other words, they can basically say, I'm not going to follow the statute. And so that would make sense if you were the king. you could say, well, that doesn't apply to me. You know what I mean? But you have to notice them. It's under martial law. Everything's under martial law. And so if you wonder why it doesn't seem like this is working these days, it's because everything's under martial law. And everything changes when you go under martial law. And under martial law, that's international law. It's part of Roman law. And the Roman cult is now in power. And that's why it's civil law. Okay? It keeps going. Anyways, governments are but trustees acting under derived authority and have no power to delegate what is not delegated to them, but the people, as the original fountain, might take away what they have delegated and entrust to whom they please. The sovereignty of every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. U.S. Supreme Court again, Luther versus Gordon. So you think about it. Do I have the power to take your property and give it to your neighbor because he does not have food to eat or for any other reason? Do I? No, I don't. Well, then neither does the government, because the only power the government has is power that I have delegated. And if I don't have that power, then I can't possibly delegate that power. But what happens is you go under martial law, and you basically have a military dictatorship. It's the same stuff that went on with the War of Independence. It's exactly the same stuff that went on with the War of Independence. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, where sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. U.S. Supreme Court, Iqbal versus Hopkins. There is no such thing as the power of inherent sovereignty in the government of the United States. In this country, the sovereignty resides in the people, and Congress can exercise no power which they have not by their Constitution entrusted to it. All else is withheld. Juilliard versus Greenman. Absolute title. This is talking about land patents. The land patent is the minument of title, such title being absolute in its nature, making the sovereigns absolute freeholders on their lands. So if you're an absolute freeholder on your land, then you are sovereign. But the problem is we get mixed up in contracts, and that's why you're having to pay a yearly rent called property taxes. Finally, the patent is the only evidence of legal fee simple title. Many ignorant people claim that sovereignty is held by the group and not individually. I was visited by the FBI and the Texas DPS in March of 2011, and they told me at that time that I'm listed as sovereign in their system. But in considering the question before us, it must be borne in mind that there is no law of nations standing between the people of the United States and their government, okay? And that comes down to martial law, because martial law falls under the law of nations. And so you can still argue, make these arguments, but the problem is that these judges, it's an uphill battle, because the judges are all, it's martial law. They'll tell you, I can do anything I want in here, and under martial law they can. And so you have to make sure and cover all the bases, because and what I would do, and that I think there's somebody on my group actually that's been talking about it recently, is bringing up Article 1, Section 8, Clause 17, which is basically says that the United States, the District of Columbia, is only in 10 square miles over there between Virginia and Maryland. and the Constitution is in Article 6, it's the supreme law of the land, and so any court cases that say otherwise are unconstitutional. So we'll continue. The powers of government and the rights of the citizens under it are positive practical regulations plainly written down. The people of the United States have delegated to it certain enumerated powers and forbidden it to exercise others. And, it's basically, the Roman cult is Satanists, okay? And they're just, that's what Trump is dealing with, I'm telling you. And they're satanic, they're evil, they lie, they cheat. It's basically the gates of hell have been opened up against Donald Trump. And you can see it every day on television. And so we should be praying for him every day. the sovereignty of a state does not reside in the persons who fill the different departments of its government, but in the people, from whom the government emanated. And they may change it at their discretion. Sovereignty then in this country abides with the constituency and not with the agent. And this remark is true both in reference to the federal and state governments. And that's a federal court case. A delegate cannot delegate. An agent cannot delegate his functions to a subagent without knowledge or consent of the principal. The person to whom an office or duty is delegated cannot lawfully devolve the duty on another unless he be expressly authorized to do so. That's a maxim of law. And so, that's why, again, like a deputy sheriff, there's got to be a letter of delegation, something appointing him to be a deputy to the sheriff. And the same thing with the government. The government cannot delegate stuff like, for example, the Federal Reserve Act. If you read, like, the Coinage Act, no, not the Coinage Act, the Gold Reserve Act of 1934, it says that Federal Reserve notes are meant for internal use of the government only. That means in the District of Columbia. And so you're using them, it's voluntary, that's why it's a privilege. You're discharging debts with limited liability, and that's why they tax you, because you're mixed up in a privilege. A delegated power cannot be delegated. A deputy cannot have or appoint another deputy. The power which is derived cannot be greater than that from which it is derived. And this is one of this last one here is a maxim that I use. And I put it in my, that we're going to be talking next weekend about the Statement of Original Status. And because that's really powerful. When you show that you have ancestors that were here prior to the War of Independence, then there's a maxim of law. There's this maxim that says the power which is derived cannot be greater than that from which it is derived. Your ancestors wrote the Constitution. And then on top of that, there's another maxim that says that no civil law can violate right of blood. And if you have ancestors that were here, and, people talk about, the different races and stuff, and who knows who was sleeping with who in the 1700s. And so I've got a YouTube video where Al Barcroft talks about this, and he says that he's seen black people even claim it. Because again, who knows who was sleeping with who in the 1700s. And, so anyways, it is true that at common law the duty of the Attorney General is to represent the king, he being the embodiment of the state. But under the democratic form of government now prevailing, the people are king, so the Attorney General's duties are to that sovereign rather than to the machinery of government. And so that's you can go after, and this is one thing I like to do, is because of this international protected person under international law, I go after bar members. There's Nelson went and come up with this bar treaty of 1947. That's got United Nations written all over it. All of these bar members are foreign agents of the United Nations. They all fall under international law. And so they're assaulting you with their international law. And that's why I think this is so powerful, because even under international law you have protections. And because technically it's the District of Columbia, okay? If all of these courts, all of these government officials everywhere in America are U.S. citizens, that is the District of Columbia that's operating. And so you're in the state of New Jersey, or New Jersey State, actually, or Texas State, or Arizona State. I mean, that's a separate, that's international law. Matter of fact, they even use what's called the international law rule that I use it in my court cases, or not my court cases, in some of my videos. There's a document that talks about the international law rule. So you're basically being forced. Technically, they're supposed to shield you from international law, but since they want to perjure the oath, there's still statutes that are available to protect you against them under international law. So I've got a subscription-based YouTube channel. Actually, I don't. That got shut down. But I do have some subscription videos. And I guess we won't talk about those because I don't have that here. But so then the law of Congress do not extend in the territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. And yes, that's true. There's lots of court cases, Supreme Court cases, to talk about that. But what they do is they just go ahead and assault you with their D.C. jurisdiction, and that's why you bring up Article 1, Section 8, Clause 17. Because that judge is sitting there playing stupid. He's not interested in protecting your rights. As a matter of fact, he's working for the prosecutor. When you really understand what's going on, it's a D.C. court, and the judge is working for the prosecutor, and they're a bunch of thieves. Anyways, so you have to know the law. You have to know what to argue, and to build a case. And so every time, you should automatically be building a case against the bar members and the judges. And the judges, you file complaints with the Judicial Council, and the bar members, you file complaints against the state bar, with the state bar. And I'm telling you, these bar members go silent so fast that their head spins. It's amazing. But I'm not done with them. I want to get some of them in jail, and because of the felonies that they've been committing, because I'm an internationally protected person, or a protected person under international law. And so because of that definition that I read to you earlier. Anyways, the Magna Carta is called the Great Charter of English Liberty. A Canadian Handbook for Judges cites the Magna Carta on page 77. Magna Carta says we will not deny or defer any man either justice or right. Yeah, and their kangaroo courts with their bought and paid for clerks and their so-called judges. Don't get me going. You're going to get me going here. Anyways, this is a Quebec court case, Canada. Perlman versus Pichet, reference habeas corpus. It talks about the Magna Carta. And the Magna Carta is not a unilateral act emanating solely from the spontaneous will of the king, as the charters of the predecessors of John. Neither is it a treaty, for we cannot say it was concluded between two legitimate and independent sovereignties, nor between two nations, nor is it a law. The barons do not appear in it as subjects, for they are freed from their promise of fidelity, and the king, brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. See, that's what they're doing to people, okay, to you and me, is they're making war on you and me, and when you submit, then you just agreed, okay? And when you sign something, that's a contract. That's another thing we're going to be covering on the advanced weekend, is about without prejudice, because under their international law, if you put without prejudice, it nullifies the signature. There's no signature there when you put down without prejudice. Anyways, Magna Carta is therefore a contract, but resembles a treaty concluded between two nations, in that one of the parties, in virtue of the law of war, can impose its will upon the other. And so that's essentially what they did with the tyrant King John, is they stuck a sword to his throat. They said, "Here, King, we want you to sign this," and so he did. Anyways, so why do we, the people, set up governments in the first place? We set them up for protection against foreign enemies, protection from each other, to administer disputes in a fair and impartial manner. The only legitimate function for government is to protect the rights of the people. That is the only legitimate function for government. So you have a hierarchy, okay? You have God, who is the King of Kings. He created we the people. We the people created the government, and the government created corporations. And what happens is we wind up being in this corporate status where we become slaves to the government if we're not careful, by taking advantage of privileges, okay? And that's how you get it. You go and volunteer for these privileges, and that's why God is in the Constitution. That's why in the preamble to the Constitution it says that we the people do ordain this Constitution. That's a Christian religious ceremony. We ordain this Constitution, so that's a Christian religious ceremony. Our rights come from God, and only God can take them away. That's why that God is in the Constitution. In Canada, the communists in Canada want to take God out of their so-called Constitution, and And that's why, because then once God is out of the Constitution, then anybody, they can do anything they want.
Like the stream dropped.
Huh?
The stream dropped.
Oh, really?
Yeah, it's back to 15 watching.
Well, it shows that it's working. Yeah, the birth certificate falls under international law. There seems to be it's bad signal. I was afraid this was going to happen.
Dropped off at delegation of powers to a trust.
Okay. I'm getting good signal.
Whose side is the millionaire?
Nothing back for you guys?
Says still buffering. One guy, some have it, some don't. I think.
I'm not showing anything.
I'm buffering.
Yeah. Showing that I got good signal. Okay, well, I'm getting the net meeting. Are we there? We're getting sound.
Yeah, we're back. I'm back. What? No, it's buffering.
I'm getting the net meeting, but the live stream doesn't seem like much is happening.
Signal looks good. Connected right away.
Yeah. Something's happening.
that's working.
I'm not getting anything in the chat.
I am.
Are you?
Now it says no connection. Have to retry.
Right. It says the bit rate is lower than the recommended bit rate.
Yeah, that was earlier on.
Huh?
That was earlier on. That was on your original connection. Not sure if you have to end it and restart it, or whether the connection will just pick it back up and it will continue again.
How long would it take to restart? That could be.
Huh?
Like, should we unplug it? Like he just said. Just
I can end it.
Yeah, I would end it and restart it. That way, pick up where we went. I would tell him maybe. That way we.
So you start talking the truth and YouTube drops you.
Yeah,
You know,
yeah,
there
that's
might
right.
be some truth to
There's
that,
total truth to that.
for sure.
Truth
That's
of the
right.
algorithm.
Signal seems to be pretty weak still. And, you know, I had somebody on and they're gone.
Is that's a separate connection though, is it?
Yeah, well, this is my webcast, and then I was live streaming it too. See, its connection says it's good, but there's nothing happening as far as
Yeah, it just said that. It says that your live stream 2 weeks ago had 334 views that we just did.
yeah, right.
62 likes. No dislikes.
Yeah, well, that's good. Okay, well, so we shut down the live stream, but we'll continue with this. I've got the recording going.
Recording is on.
Okay, so we'll just continue. So anyways, the individual may stand upon his constitutional rights as a citizen. He's entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life, liberty, and property. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a judicial power of warrant, a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. And that's Hale versus Henkel, U.S. Supreme Court again. This Cube Yard is the guy that does my website, and he asked me to not advertise his stuff anymore. So, anyways, there's at least two major classes of citizens. You can be state or federal. There is in our political system a government of each of the several states and the government of the United States. Each is distinct from the other and has citizens of its own. One may be a citizen of a state and yet not a citizen of the United States. They always ask you if you're a U.S. citizen. Well, that's the worst thing you can be. There is a clear distinction between national citizenship and state citizenship. Instead, this provision protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. And that's as recent as 1993. Citizenship in the United States does not entitle to privileges and immunities of citizens of the state, since privileges of one are not the same as the other. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. The only absolute and unqualified right of the United States citizen is to residence within the territorial boundaries of the United States. So U.S. citizens don't have any rights, basically. Such construction ignores the rights of a state in virtue of its sovereignty to confer citizenship within its own limits, where the rights incident to such a status are not of the citizenship mentioned in the federal Constitution. It does not follow that because one has all the rights and privileges of a citizen of a state, that he must be a citizen of the United States. Such a distinction has long been recognized in this county, and that's a Mississippi court case. The rights of the original judicial citizens of the states as such are not under consideration in the 14th Amendment. They stand as they did before the 14th Amendment and are fully guaranteed by other provisions.
That's a good one.
Yeah. Well, the 14th Amendment's a martial law amendment. Civil rights under the 14th Amendment are for federal citizens and not state citizens. Federal citizens, as parents, have no right to the custody of their infant children except subject to the paramount right of the state. There's where CPS starts getting mixed up in your personal life and stuff. And the 14th Amendment is actually a revision. The same thing exists in Canada. The charter adopted in 1982 refers to citizens of Canada several times. The courts have told us that laws of Canada are federal laws. Citizens of Canada are federal citizens. It's a lot more murky in Canada. Canadians include state citizens or provincial citizens and federal citizens. And this is the charter, every citizen of Canada, and it's talked about in Section 3 of the Charter of Rights and Freedoms, Section 6, Section 23, talks about citizens of Canada. Every citizen of Canada has the right to vote in an election of members of the House of Commons and of the Legislative Assembly to be qualified for membership therein. Notwithstanding anything in this charter, the rights and freedoms referred to in it are guaranteed equal to male and female persons, fictitious entities. This is a California court case. It's evident that they, U.S. citizens, have not the political rights which are vested in citizens of the states. They are not constituents of any community in which they are vested any sovereign power of government. Their position partakes more of the character of subjects than of citizens. They are subject to the laws of the United States but have no voice in its management. If they are allowed to make laws, the validity of these laws is derived from the sanction of a government in which they are not represented. Mere citizenship they may have, but the political rights of citizens they cannot enjoy. That's 1870, People versus De La Guerra. And this is a Merriam-Webster dictionary. Subject, national citizen, may indicate being a member of a sovereign state, especially ones showing democratic forms and usages, owing it allegiance, sharing in individual political rights. Subject may imply a state of subjection to a person such as a monarch without much sense of membership in a political community or sharing in political rights. National, as a more general word, may apply to anyone owing permanent allegiance to a nation, indicates one belonging to a broad category that includes both people who are legally citizens or subjects, and also people who have not attained such legal status. So you can be a national without being a citizen or a subject. And that's really where you want to be. Subject, one that owes allegiance to a sovereign and is governed by his laws. The natives of Great Britain are subjects of the British government. Men in free governments are subjects as well as citizens. As citizens, they enjoy rights and franchises. As subjects, they are bound to obey the laws. The term is little used in this sense in countries enjoying a republican form of government. In our opinion, it was not the intent of the legislature to restrict the operation of the statute to those who were subjects of the United States government and exclude therefrom unnaturalized residents of foreign birth, whether white or black. On the other hand, the 14th Amendment, upon the subject of citizenship, declares only that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Here there is a limitation to a person born or naturalized in the United States, which is extended to persons born in any place subject to their jurisdiction. And that's Downs versus Bidwell. That's the same case that talked about two national governments. Elk versus Wilkins. Persons declared to be citizens are all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject. And that's Elk versus Wilkins, U.S. Supreme Court, 1884. Merely being native born within the territorial boundaries of the United States does not make an inhabitant a citizen of the United States subject to the jurisdiction of the 14th Amendment. There is in our political system a government of each of the several states and the government of the United States. Each is distinct from the other and has citizens of its own. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside independently of that instrument. Why do you think Nancy Pelosi, as U.S. Speaker of the U.S. House of Representatives, say they have to pass legislation so they can find out what it says? So check out my other videos, Bankster Thieves, 1, 2, 3, 4, 5, and 6 now. Churchianity series, bankrupt corporate so-called governments. Bar members, 1, 2, 3, 4. There's a 4 and a 5, I think. Do it yourself, how not to volunteer for the selective service. Martial laws here, do it yourself, no income tax. Do it yourself, estoppel certificates. Everything is an illusion. Void judgments, do-it-yourself kangaroo courts, 1 through 18 now. The term citizen in the United States is analogous to the term subject in the common law. The unborn are not included within the definition of person as used in the 14th Amendment. That's what the Nazis did when they started killing off the Jews, is they said they're not persons, so we can go ahead and kill them. And that's what they do with the unborn. That's the U.S. Supreme Court. Hopefully that gets overturned pretty soon. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. So they converted citizenship into the opposite of what the Founding Fathers intended. It's exactly what they did. So what's going on here?
Saving or anything on the YouTube, that's what that is.
Sorry?
It's not saving on the YouTube, that's what that is.
It's taking
Just not
time.
streaming.
Yeah. It's something's happening, but at least I think it's again comes down to poor signal. Citizenship is a political status and may be defined and privilege limited by Congress. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. The 14th Amendment referred to slavery, consequently the only persons embraced by its provisions for which Congress was authorized to legislate in the manner were those then in slavery. No white person born within the limits of the United States and subject to their jurisdiction or born without those limits and consequently naturalized under their laws owes his status of citizenship to the recent amendments to the federal Constitution. That's Van Valkenburg versus Brown. All citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lead, sell, hold, and convey real and personal property. That's current law. That's currently what's at 42 U.S.C. 1982. Slavery was brought into America by the Roman cult to create the mechanism by which everyone would become enslaved. When the rights of the least of us are violated, we're all diminished. Al Capone was a gangster in Chicago during Prohibition. Al Capone was the first guy who was jailed for tax evasion, and now they jail all sorts of people for these so-called crimes. See Debtor Prisons Are Everywhere video. Therefore, U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. A U.S. citizen, upon leaving the District of Columbia, becomes involved in interstate commerce as a resident, does not have the common law right to travel as a citizen of one of the several states. So again, because U.S. citizens are commercial. After the adoption of the 14th Amendment, a bill which became the first Civil Rights Act was introduced in the 39th Congress, the purpose of which was to secure to the recently freed Negroes all the civil rights secured to white men. None other than the citizens of the United States were within the provisions of the Act. So the Civil Rights Act was for former slaves. All of these statutes are a cheap imitation of common law that essentially convert rights into privileges. By this means, citizens' birthrights become of no effect and their rights are reduced to the inferior character of statutory civil rights, mere legislative privileges. And that's taken from a book called The Non-Ratification of the 14th Amendment in the case Diet versus Turner by this Judge H. Ellett of the Utah Supreme Court. At common law, they're absolute rights. Statutes can and are changed. Statutes are ignored under certain circumstances. A subject, one who owes allegiance to a sovereign and is governed by that sovereign's laws. Speaking generally, we may say that the terms subject and citizen are synonymous. Subjects and citizens are alike. Those whose relations to the state is personal and not merely territorial, permanent, and is not merely temporary. This equivalent, however, is not absolute, for in the first place, the term subject is commonly limited to monarchical forms of government, while the term citizen is more especially applicable in the case of republics. And that's Black's Law Dictionary, 8th edition. Finally, it's to be noticed that the term subject is capable of a different and wider application in which it includes all members of the body politic, whether they're citizens or resident aliens. All such persons are subjects, all being subject to the power of the state and to its jurisdiction, and as owing to it, at least temporarily, fidelity and obedience. Residence. This is taken from the Law of Nations by Vattel, Book 1, Chapter 19, Section 213, page 87. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country, being bound to the society by reason of their dwelling in it. They are subject to its laws so long as they remain there, and being protected by it, they must defend it. Although they do not enjoy all the rights of citizens, they have only certain privileges which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They are a sort of citizen of a less privileged character and are subject to the society without enjoying all of its advantages. Their children succeed to their status, for the right of perpetual residence given to them by the state passes to their children. So that's residence. So the key is not to use those kinds of words, in my opinion. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile is Sovereign Living. My Facebook community page, I deleted it due to censorship on the part of Facebook, and I have a private group on Facebook that I haven't been there in ages, and there's other people that are managing it, and they can have at it for all I care. Anyways, I've got a Yahoo private group, a Google private group. The Yahoo group is going to get deleted on the end of December because of Yahoo is shutting it all down. And I've got a Twitter profile, Engineer Win. One does not necessarily become a non-resident by absconding or absenting himself from his place of abode. So again, it comes down to the words you use. You can be a non-resident just by not being involved in their contracts, is what it comes down to. The residence is the fact of being officially present, statutory benefice of an incumbent in a statutory presence of an incumbent in a benefice. It might be correctly said that there is no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be called a citizen of the United States, although technically and abstractly there is no such thing. Every taxpayer is assessed a trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. And so a U.S. citizen's a taxpayer, and so that's assessed a trust. It's commercial. Henry Bolins, 1912. Slater's protestation to the effect that he derives no benefit from the United States government have no bearing on his legal obligations to pay income tax. Unless a defendant can establish that he's not a citizen of the United States, the IRS possesses authority to attempt to determine his federal tax liability. And this is the D.C. Code located at 31 Stat 1432. It says, the legal estate to be the cestui use. And this is more D.C. Code, which is now known as United States Code. And be it enacted and be it further enacted that in interpretation and construction of said code, the following rules should be observed, namely the word person shall be held to apply to partnerships and corporations. Presumption of death. They presume you're dead, so then that's a cestui trust. And here's where it's codified. 15 U.S.C. Section 44, definitions. Corporation shall be deemed to include any company, trust, so-called Massachusetts Trust or Association, incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital or capital stock or certificates of interest. And then it goes through the same definition, but does not have shares of capital or capital stock or certificates of interest. And this is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holes, they devised a new method of conveyance, by which the lands were granted not to themselves directly, but nominal fees to the use of the religious houses, thus distinguishing between the possession and the use and the receiving the actual profits, while the season of the land remained in the nominal fee, who was held by the courts of equity, then under the direction of the clergy, that's the Roman cult, to be bound in conscience to account to assess the use for the rents and emoluments of the estate. That's taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. So this is all started by the Roman cult, is where it's all started. That's all in my book. We're going to talk about some court cases to talk about race. The court cases about race are used to talk about what was considered subjects, because the so-called 14th Amendment, all subjects became U.S. citizens. See the 14th Amendment's unconstitutional video. It's a revision. See the slavery equals Roman cult video. Slavery is introduced in America as a mechanism to enslave everybody. And Chisholm versus Georgia, but they were sovereigns without subjects unless the African slaves among us may be so called. No black or mulatto person or Indian shall be allowed to give evidence in favor of or against a white man. The words Indian, Negro, black, white are generic terms designating race. Therefore, Chinese and all other people not white are included in the prohibition from being witnesses against whites. Excluding Chinese witnesses in suits to which white persons are parties is affirmed. The indice of color is not an infallible test of the competency of a witness under the Act, excluding blacks, mulattoes, and Indians from testifying for or against white persons. See, these are all old statutes and court cases. In a criminal action against a white person, a black or mulatto person, although the injured party cannot, under the statute, be a witness against the defendant. The words in favor of or against any white person in the Act prohibiting persons of one half or more Indian blood or Mongolian or Chinese from giving evidence refer to the defendant alone in a criminal action. The 14th Amendment to the Constitution of the United States does not conflict with the power of the legislature in the exercise of its discretion to exclude Chinamen from the right to testify in the state courts. So they were obviously prohibiting anybody that wasn't white from testifying in courts. And that's a lot of these court cases talk about. The right of trial by jury in civil cases guaranteed by the 7th Amendment, the right to bear arms guaranteed by the 2nd Amendment, have been distinctly held not to be privileges and immunities as citizens of the United States guaranteed by the 14th Amendment against the abridgment by the states. And in effect, the same decision was made in respect to the guarantee against prosecution, except by an indictment of a grand jury contained in the 5th Amendment, and in respect to the right to be confronted with witnesses contained in the 6th Amendment. So U.S. citizens really don't have any rights. Remember that one court case that said the only absolute and unqualified right of a U.S. citizen is to live within the territorial boundaries of the United States. The technical niceties of common law are not to be regarded. A jury does not figure ordinarily in the trial of an admiralty suit. The verdict of the jury merely advisory and may be disregarded by the court. The rules of practice may be altered whenever found to be inconvenient or likely to embarrass the business of the court. Well, so we'll just make the rules up as we go along. That's what they do. You see it happening all the time. A court of admiralty acts upon equitable principles. A libel of information does not require all the technical precision of an indictment at common law. If the allegations describe the offense, it is all that is necessary, and if it is found upon the statute, it is sufficient if it pursues the words of the law. And this is actually an old court case. It's called the Emily versus the Carolinas, 2 vessels. The Congress shall have power to dispose of and make all need for rules and regulations respecting the territory or other property belonging to the United States. That's U.S. Constitution, Article 4, Section 3, Clause 2. And this is Georgia Department of Driver Services. And it says here, the highlighted stuff, what we're going to do is I've got it summarized over here. It's signed by General Counsel for the Georgia Department of Driver Services. Anyways, the highlighted stuff is basically put right here, and then the where it's not highlighted, I put the dots, which is, you know what I mean? Anyways, the statute creates a rebuttable presumption of residency for anyone who meets the following criteria. However, no such person shall be considered a resident for purposes of the statute unless such person is either a United States citizen or an alien with legal authorization from the U.S. Immigration and Naturalization Service. So, again, green card, right? Statutes do not apply to state citizens. I cannot delegate authority to regulate you. Statutes are for U.S. citizens, which is government employees. There have always been two classes of citizens. The U.S. Constitution, Article 4, Section 2, Clause 1 says, "A citizen of each state shall be entitled to all the privileges and immunities of citizens in the several states." So that's two classes of citizens right there. And then you go to Leviticus 19 and 34, "The stranger that dwelleth among you shall be unto you as one born among you, for thou shalt love him as thyself, for you were strangers in the land of Egypt." That's how they enslave people, is with the two classes of citizens. "Love ye therefore the stranger, for you were strangers in the land of Egypt." Deuteronomy 10 and 19. And we call ourselves Christian. And this is the Carlaw case that I read earlier. Strangers have a social security number, and Deuteronomy 23, 19 to 24, "Thou shalt not lend upon usury to thy brother, usury of money, usury of victuals, usury of anything that is lent upon usury. Unto a stranger thou mayest lend upon usury, but unto a brother thou shalt not lend upon usury." And so the Roman cult, interest, is they don't call it usury anymore, they call it interest. And the Roman cult has authorized it, and the Roman cult is getting a royalty from it, is what's happening. Anyways, the bankster thieves will not loan their so-called money unless you can prove you're a resident. A U.S. citizen does not have access to the first 8 amendments against the powers of the federal government, has no right to a trial by jury, has no right to keep and bear arms, has no right to face your accuser, has no right to give evidence against state citizens, has no right to common law indictment, has mandatory military service, mandatory taxes, and may vote, but it doesn't mean anything, and have no political power. That's where the justification is to rig the elections to. You can be a national without citizen. That citizenship is part of a political community, and it talks about it in the U.S. passport application right here, a non-citizen national. And this is part of the application, non-citizen nationals. It is, however, true that in all common law countries it is always and consistently held that the wife and minor children take the nationality of the husband and father. That is common law doctrine. Immigration laws only apply to U.S. citizens. If I am joined in holy matrimony with a girl from Russia, she becomes an American national. In doing this, I shall have occasion, incidentally, to evince how true it is that states and governments were made for man, and at the same time how his creatures and servants, at first deceived, next vilified, and at last oppressed their master and maker. Let a state be considered as subordinate to the people, but everything else be subordinate to the state. The individual, unlike the corporation, cannot be taxed with the mere privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state, but the individual rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. So income tax is actually an excise tax, a privilege tax. This is Acts 22, 25 to 29, "And they bound him with thongs. Paul said unto the centurion that stood by, Is it lawful for you to scourge a man that is a Roman and uncondemned? And when the centurion heard that, he went and told the chief captain, saying, Take heed what thou doest, for this man is a Roman. When the chief captain came and said to him, Tell me, art thou a Roman? And he said, Yes. And the chief captain said, With a great sum obtained I this freedom. And Paul said, But I was freeborn. Then straightway they departed from him, which should have examined him. And the chief captain was also afraid, after he knew that he was a Roman, because he had bound him." So again, this citizenship has always been here. It's as old as time itself. In order for a member of the sovereignty to be subject to the regulation anyway, they must agree to it. It's by contract. It must be knowing, willing, and intentional. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private corporate commercial paper and securities is concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. That's why you cannot pay their extortion, their excise tax, filing fees. A penal action is an action on a penal statute, an action for recovery of penalty given by statute. So you think about it. I don't know if they have a New Jersey penal code, but they definitely have a Texas penal code.
I don't think we do. I think it's,
But if you read in the New Jersey Criminal Code, it'll have penal stuff all over the place. You see what I'm saying?
Yeah.
So it is penal, for sure. Where an action is founded entirely upon a statute, the only object is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by a statute for the crime or offense against its laws. The noun penalty is defined forfeiture, to be forfeited for non-compliance with an agreement. It's a contract. So where's the contract? The words forfeit and penalty are substantially synonymous. A penal action is one founded entirely on statute and brought the sole object of recovering a penalty or forfeiture imposed as punishment for a specific offense, while remedial action is one brought to obtain compensation or indemnity. A penal action is a civil suit, so there's no such thing as a real criminal action. They're all civil. A penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions, on the one hand closely related to criminal prosecutions, on the other private injuries for which the party aggrieved may by statute recover punitive damages. So if you pin the judge down, he'll say it's quasi-criminal. Whenever the Uniform Code creates a presumption with respect to a fact and provides that a fact is presumed, the trier of fact must find the existence of the fact, and unless and until evidence is introduced that supports the finding of its non-existence, which is just about impossible. In an action with respect to an instrument, that's Uniform Commercial Code. This is Uniform Commercial Code. In an action with respect to an instrument, the authenticity of and authority to make each signature on the instrument are admitted unless specifically denied in the pleadings. If the validity, so then they forge your signature onto a contract, and how are you supposed to say that they did that when you don't even know that it's happened? You see what I'm saying? And that's what they do, is they forge your signature onto a contract. The following rules apply in an action on a certificated security against the issuer unless specifically denied in the pleadings. Each signature on a security certificate or in a necessary endorsement is admitted. If the evidence of a signature is put in issue, the burden of establishing effectiveness is on the party claiming under the signature, but the signature is presumed to be genuine and authorized. So you have to make an affidavit and deny it and know where they did it and how they did it. Otherwise, you're screwed. Individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to merely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association of which they are agents or officers, and they are bound by its obligations. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law in its humanity affords him. He is for the time being a slave of the state. And they should be put to death for this. They put that everybody in prison is put into slavery, is what they're put into. And these judges should be put to death. In Deuteronomy 24:7 it says, if a man be found stealing any of his brethren, the children of Israel, and make merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. This is all satanic, this whole system, all these prisons. There's more people in prisons in America than any other country on the planet when you look at the percentage of the population, and it's all satanic. The state citizen is immune from any and all government attacks and procedure absent contract. Every man is independent of all laws except those prescribed by nature. He's not bound by any institutions formed by his fellow men without his consent. Taxpayers are not de jure state citizens. State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. The rights of individuals are restricted only to the extent that they've been voluntarily surrendered by the citizenship to the agencies of government. So it's all a contract. This is a letter from an Arizona senator, Wayne Stump. I've got copies of the letter in my laptop case. Anyways, if it says here, this was sent in December of 1985. It says it's come to my attention that numerous individuals in our state have rescinded all of their contracts with the United States federal government, the state of Arizona, and each of its political subdivisions, establishing themselves as freemen under the archaic national constitution of the Republic of the United States of America. Consequently, they may be driving without evidence, without auto registration, driver's license, or any other evidence of contract. Anyways, because many law enforcement personnel may be unaware of the contractual nature of auto registration driver's licenses, it is conceivable that the situation may lead to confrontation between these individuals and law enforcement personnel. I urge you to inform yourself and your personnel about this matter as soon as possible. If you'd like to be briefed by someone knowledgeable on the subject, please contact me. In the meantime, inasmuch as this procedure is entirely appropriate when properly carried out, I would like to be personally notified of every such instance of confrontation. So he's saying this is at Arizona State Center and it's perfectly appropriate to do that. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. Ignorance of the law is no excuse. Anytime you get anything from the government, it's an implied contract and brings you into their jurisdiction. So anytime you register for anything or make application for anything from the government, you're giving them a power of attorney to make a legal determination for you and represent you, and you're making them competent in your affairs. You're telling them you're a person. You're converting yourself into a slave. All statutes are written very carefully and do not apply to members of the sovereignty. Members of Congress or legislatures cannot write their own statutes. 99% of the time, the government is technically correct. They have lawyers. When they write a statute, it has to go to a bunch of lawyers, and they have teams of lawyers that review all this stuff, and basically it's got to get past them. It's not up to the government to tell you that you're a member of the sovereignty. The government lawyers make up a statute that properly applies to those entities they have jurisdiction over. The burden's on us to assert our sovereignty. Do you know who you are? Are you going to let some bureaucrat tell you who you are? That's essentially what happens. If a member of the sovereignty gets unknowingly involved in something that operates as a contract by which he might lose his sovereignty, he's made a mistake of law and fact. So you got to make the argument. The courts have ruled that the government is not the protector of the Constitution. If the government is not the protector of the Constitution, then who is? It's up to the people who are supposed to protect the Constitution. How do we protect the Constitution? We protect the Constitution by challenging what the government does through the courts and administratively. The burden's on you to know and understand the law and to assert your sovereignty. All contracts have to be knowing, willing, and intentional. None of the contracts entered into with the government by which you might lose your sovereignty are knowing, willing, or intentional. And the sovereignty of the people is unalienable and imprescriptible. In other words, it's treason for the government to do that. So you start bringing it up and they kind of run away and hide. In order to regain your sovereignty, you must assert it. When you assert your sovereignty, you build a case with evidence that you can use in court at a future date should you need to do so. I send documents to chiefs of police and those kinds of people, and basically to put them in a position that they have to honor their oath of office, and if they don't, then I file criminal complaints against them. But it's extremely difficult these days because the corruption is so widespread. And Trump, you see it happening with Trump even every day. The government liars may turn it over to a bureaucrat who may respond on point. You have to know the law and know what you're doing. If the government were to admit you're right, they'd be admitting to treason, extortion, genocide, and other felonies. The government lawyers will probably not respond at all. And that's usually what happens when I send my stuff out. if you want to be truly sovereign, you have to be self-reliant. You must not only talk the talk, you got to walk the walk. You got to be knowledgeable about the law and how it works. Be prepared to take the initiative in court if necessary. Make it known and know in certain terms that you're all of the above. It's all about slavery. It's not about race. A U.S. citizen or a citizen of Canada or a citizen of Australia is a slave. Either you're the king or you're a slave, and there is nothing in between. If you participate in their color of law statutes, then you've agreed to be their slave. If you need some bureaucrat to explain the law to you, then you're incompetent and a slave. It's only involuntary servitude that is unlawful. That's the 13th Amendment, involuntary servitude. If you volunteer, then you volunteer. If a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. Nobody said it'd be easy, but it is possible. If tyranny and oppression come to this land, it will be in the guise of fighting a foreign enemy. What's the alternative? Anyways, that's the citizenship presentation. Okay, so we just finished the citizenship presentation. I shut down the live stream because it wasn't working, and but it is recorded. All this stuff is recorded, and so I'll be making it available for Chris. Chris, did you have anything you wanted to go through? I see you're back. The signal must have got bad or something, and so we're using a different source for Wi-Fi now. But is there anything in particular you were interested in seeing? Any presentations? Okay, he's got it there. Okay, well, what I can do is I can go through asserting sovereignty. Well, this one is it doesn't give you the steps, really. It gives you the basis for the citizenship issues, the one that we went through. So you didn't, there's a video. I'll send you a link to the video. This is all recorded anyway, so it'll get uploaded to YouTube. But so you'll get the video anyways. But I can do, if you want the steps on what you do. Everybody technically is sovereign, but I have a procedure that I developed. Actually, it's Rice McLeod's procedure, who's the former Attorney General of the Republic of Texas. Technically, everybody's sovereign. The Supreme Court in the case Carlisle versus United States, I think I went through that. You might remember that. It said everyone not privileged is sovereign. And so really what you do is you make an affidavit of corporate denial and record that with the county. Now, I can go through this asserting sovereignty one. Which goes through how I developed this case, how I developed this procedure, but it's really Rice McLeod's procedure. Rice McLeod was he's dead now, but he was a former Attorney General for the Republic of Texas, and he was a real down-to-earth sort of guy. He, like for example, and I think that this is so well said, he said that said the biggest problem in this world is third parties. And you know, all lawyers are third parties, right? And he
Yeah.
said that these lawyers go into court and they say this guy did this and this guy did that, and they don't have any first-hand knowledge of anything. And he said, and then he hit the nail on the head. He said, so why on earth would you want some third-party preacher involved in your relationship with God?
Well, Glenn, isn't that why they take you to a separate room to speak with your attorney?
There you
Your
go.
lawyer. That's because you're making a contract with them when you do that.
Of course, that's right. Yeah. Matter of fact, Carrie Zolman, that developed the Form 1020, that's so brilliant. He has a contract with the attorneys, and when he was indicted, and he was indicted with 17 other people, and his last name's Zolman, so it's with a Z, right? He was the last one. Did I tell you about that?
Off camera, it's been
Yeah,
mentioned.
yeah. So anyways, yeah, he basically tied him up in knots, and all the rest of them went to jail, and spent the rest of their life in jail, and he went home that day, and he just tied him up in knots, and he refused to. He just refused to. He would just he didn't give evidence against himself, and really it comes down to words. So first thing he did is he had a contract, right, with the attorneys. He says, okay, no problem. You want to give me an attorney? Then here's a contract, Mr. Attorney, and I want you to sign it. And the contract basically says that you're gonna follow my instructions, or you agree to do the time. And so the attorney wouldn't agree to that. You know what I mean?
Yeah.
And so then he didn't have an attorney all of a sudden. And so then he was busy making his arguments, and he started off with a glossary. He says, well, I got this glossary of the definition of words, and I want to use it. And they wouldn't even look at the glossary, and they wouldn't use the definition. They wouldn't use it at all. And actually, the definitions were all standard ones and everything, but they wouldn't touch it. And so then they said stuff like, he says, so what's your name? And he says, well, my dad calls me Bubba. And that's where it started, you know.
Yeah.
and it took him 8 hours just to get his name out of him. Anyways, so and they would say something to him, and he'd say, you know, and they'd say, are you crazy or something? And he'd say, well, I give you the glossary, you know, until we know what the words mean that we're using here, I don't know what you're saying, you know. And so he would sit there and just say all sorts of stuff, and it took him 8 hours to get his name out of him. And so he's really brilliant about that stuff, eh? So anyways, I don't know how I got sidetracked on that, but